What steps can individuals take to protect their ownership rights in a product or creation when there's a potential for conflict with their employer or organization?
All right, very good question. So, what can someone do to protect their ownership rights in a product or creation when there's a potential for conflict with their employer or with another organization? I think that's a great question. Generally, we advise businesses, but there are many instances in which we will advise a founder or an individual as part of their exit because they intend to form a business almost immediately after exiting or as part of exiting. Or it could be that they already have a business and they are working with one particular organization in a large capacity that consumes a lot of their time. And then, they want to know, well, how do I protect this? Because this relationship with them, while it's taking up a lot of time now, and it maybe is the only thing I'm doing now, it could very well end up being something that is that they want to return to, and they want to make sure there's clarity around what's mine and what's theirs. So the biggest thing I would tell parties, and I particularly tell owners of their own work product and intellectual property and of businesses and founders looking to set up a business, is you want to clarify things in writing. That is the starting point, is you want to get clarity around who owns what. So often people are looking to move so fast that they feel like these are just details that can get sorted out later. But really, the best leverage that you have is if you make this a requirement to get sorted out now before the relationship begins. Think about it. If someone is really interested in working with you now, and the only thing that has to get done for that to get started now is the one thing that you're asking them to do, which is that there is clarity around who owns what, it gets put in writing and it gets signed, right? So, of course, a lot of times people say, but I really want it. And they see themselves as having, they can see themselves as having less of a negotiating power. And so I just need to get on side with them and I can sort that out later. But honestly, I think people should own their negotiating power. If somebody wants you, they want you, right? And if this is important to you, then you've got to show them that it's important to you. If they see that there's something important to you and you're willing to just move forward without getting this signed and getting this clarified, that is telling to them. Now, they may be getting what they want in that moment regarding that. I've represented the companies where they've seen this sort of behavior from others that come in, and it's not a good look for many of them because they understand if they're willing to do that here, where else are they willing to do that, right? And how will that actually affect us negatively? Best protection is clarify it in writing and get it signed. Now, here's where people get it wrong. Creative works is only effective with the under US copyright law if it is a signed writing. So by way of example, whenever I get, and Anna knows this, whenever I get photographs of myself for marketing materials and things like that, I require the photographer to provide me with a signed work made for hire provision. And people will say, oh, well, it's in the agreement, or I'll just send you an email confirming it, or it's part of my terms that they don't sign, right? Maybe there's like an electronic acceptance by the person purchasing, but the photographer is not signing it, or maybe someone in the business other than the photographer is signing it. And here's the thing, under US copyright law, it's the person taking the image and the videos that owns the copyright, even if it's a work made for hire, unless that person, that person has signed a work made for hire provision and yes, signed it. And so sometimes the signature itself and the writing itself is what matters most of all. For the vast majority of IP protection needs, not all of them, but for, well, let's say for many, a let's say, a big part of the IP protection needs for businesses and creatives and non-creatives who otherwise have intellectual property. It's that process of coming to a writing where both parties are willing to sign it. That is the value, a huge part of the value. It's not the only thing that matters. And that's why I tell people it's not enough to just pick a document and have it signed and it looks like the kind of thing that will protect you. You've got to understand what it is, what it says, and how it may play out in reality, in practice, to have true protection. And that back and forth inquiry with the other party, that negotiating and refining and excising out this and adding that as you consider different provisions, and hopefully with the help of counsel, that is where you have what's called the meeting of the minds. And that is a huge value, because as the relationship continues and matures, that meeting of that minds, the understanding that was developed at that point in time, is what will keep so many things from going to a hard disagreement later on. Being able to leverage, well, you signed this and this was our understanding and we talked about it. We specifically excluded that. Being able to say things like that puts people in the position of having to honor their word, honor the experience that both of them had when they were working through what is our agreement here. So yes, you want to get it in writing. You want to get it signed. In certain circumstances, you have to have it signed. But importantly, with that is you want a true meeting of the minds, which means that you can't just be pulling up anything and signing it and thinking that that works. You really want to have an understanding of what you're signing, and you want them to have an understanding of it. Now, you can't control them, right? There's only so much you can control them, but ask yourself, do you genuinely believe that these are people who are participating in that process in good faith? And do you believe that they are people who will honor the terms of what is being signed? So that, I believe, is the best protection. I see carve outs all the time when it comes to employees, even, and independent contractors and consultants, which is the same thing as an independent contractor, at least for FLSA standards. But I see these situations all the time where people are very specifically considering their IP protection clauses and editing them to make it appropriate for their needs. If you have something that's pre-existing, you want to clarify what is that pre-existing information and material. And if you plan on developing something with that business and you have your own business and are operating through your own business, then you want to clarify, well, what becomes yours and what remains mine? And if there's something that's yours, do I get a license to it? And so again, very careful consideration of your IP protection clauses, and probably something you want to do with a lawyer. I mean, I'm just trying to think of scenarios where it makes sense to avoid using a lawyer, and I can't think of any.